All right, we might resume. Just to make sure you get that point. We can't just leave it there. Next one, social media now. We could have a whole hour talking about social media. It is amazing where we're at. When I first went to LPLC about 3 years ago now, I went to a seminar on social media, and I think at that stage it was really just emerging. It wasn't. There were a handful of firms, with Twitter accounts and Facebook accounts, but it was quite new. I mean, within 3 years now, I think most law firms have Twitter accounts and Facebook accounts, and even the courts, I think, are now tweeting. It's become common practice. We all are publishers of information. And obviously, when we're doing that in written form, there's greater dangers with respect to confidentiality. In terms of where it's appearing, my observations is it's certainly appeared in the unfair dismissal area, where employees have been dismissed because they've put on a Facebook page some confidential information, or they've slagged off their employer in a tweet, and that's been used as a ground for dismissal, and then they bring on an unfair dismissal claim. So that's one area. Obviously defamation has arisen. Interestingly, I really wonder whether there will be, at some stage in the future, some sort of disciplinary prosecution or claim for damages, because it does remove, because it's in writing, it makes it easier for, firstly, a client to become aware of the disclosure of confidential information, and also easier for the client to prove there's been a disclosure of confidential information. I mean, there'll still be the barriers of proving loss, but I think it becomes more likely in the future. A document to be aware of, it's in the material that I've handed out a copy. The LIV have promulgated guidelines for the ethical use of social media. I'm amused when I read it, because the example they use of a possible breach is where a practitioner tweets that she's in a certain location, either through text or geotagging, and she may unintentionally disclose she's working with an identifiable client and therefore breach the duty of confidentiality. Now, to my mind, that's a fairly esoterical example. It's sort of really out there. I think there are a lot more tweets and Facebook posts and lots more information or things you could do that would come closer to the mark. But there it is. You need to be careful even to that extent. There's heaps of articles written about that if you wanted to look into it. But certainly, it's a good question to ask. Does your firm have a social media policy? How is your firm using social media? What sort of vetting, what sort of education do you give your employees about how they use social media? Because it's obviously an important tool, marketing tool, but it does involve lots of risks. Another area source that I found fantastic when I was doing this research was that there are these LIV Ethics Committee rulings available. They're available on the internet. They're actually searchable, and they go back to 1995. So I was easily able to search for confidentiality, came up with a whole heap, waded through them, and I've put a lot of them in the material that I've handed out. I'm certainly not going to go through them all, but if you wanted to read through some examples of real-life ethical scenarios and the result of what the Ethics Committee thought, sometimes you might agree with them, sometimes you might find their rulings somewhat surprising, but that's the nature of ethics. We can all have different points of view. But it is a great resource if you're looking even at another area of the ethics. One of the ones that I might look at, as I said, there's lots there, but one of the ones that I actually think is probably more common, and I've certainly come across it in practice, is where a practitioner will use the information they've obtained from a client in a suit against the client for fees. It seems that if the client doesn't pay a a lawyer. A lot of lawyers think it's open slather, they can go hell for the leather against the client and use all of the resources at their disposal. That's actually not the case. This particular example was where a practitioner appeared for a defendant in a criminal trial. They were worried about the client having capacity to give instructions. They obtained a psychiatric report, which obviously, well, reading between the lines, indicated that the client wasn't able to give instructions. They subsequently withdrew from the matter, and then later on there was a dispute about the fees. They wanted to pursue the client for fees, but they wanted a litigation guardian appointed in that suit for fees, and they were wondering, I think they went to the ethics committee and asked whether they could use this medical evidence they'd obtained, the psychiatric report, in support of their application that a litigation guardian be appointed. And the answer was no, that's confidential information, it's privileged information that you've obtained. That confidentiality belongs to the client. It's not available for your use in your proceedings against the client. So that's a real life example. I've seen examples of it in suits against clients where lawyers have simply used information obtained wrongly. In fact, a solicitor called me recently talking about a matter where a client had come to see them. The client had been sued by their former lawyers in the Supreme Court, so obviously a lot of fees involved in a family law matter, not surprising. And the lawyers suing in the Supreme Court had put on a summary judgment application and tendered or exhibited to that an affidavit that the client had sworn in the family court proceedings saying certain things. Now there's specific rules in the Family Law Act about confidentiality of family court proceedings, so I think that was really, if not a breach, it was certainly going close to it. So it's something to be aware of. You don't really have open slather when you're suing a former client for fees to use all the information you've got. I'll jump over the rest of these. Certainly, if anyone has any questions about them, if you've read them, you can ask about them. And then give you a break by showing you another video. It sort of opens up the bigger picture. Some of you might have seen it before. It's a CBS News report. But it does give, I think, food for thought. I think it's a bit scary, both from a personal point of view and a professional point of view.
A warehouse in New Jersey filled with 6,000 used copy machines, ready to be sold. And almost every one of them holds a secret.
That's it?
That's the hard drive.
Nearly every digital copier built since 2002 contains one of these, a hard drive. Like the one on your personal computer, it stores an image of every document scanned, copied, or emailed by the machine. In the process, turning an office staple into a digital time bomb, packed with highly personal or sensitive data.
We might find as many as 20,000 documents on it.
If you're in the identity theft business, this has got to be some kind of pot of gold.
Social security numbers, birth certificates, bank records, income tax forms. That information, I would think, would be very valuable.
John Johnson and Sacramento-based company Digital Copier Security developed software that can scrub all the data on hard drives. He's been trying to warn people about the potential risk, with no luck.
Nobody wants to step up and say, we see the problem, we need to solve it.
So we went with Johnson to this warehouse, one of 25 across the country, to see how hard it would be to buy a used copier loaded with documents. Turns out, it's pretty easy.
I get equipment in all day, every single day.
Johnson picked 4 machines based on price and the number of pages printed. In less than 2 hours, his selections were packed and loaded onto a truck. The cost? About $300 each.
Come on back.
Until we unpacked and plugged them in, we had no idea where the copiers came from or what we'd find. We didn't even have to wait for the first one to warm up.
We've got some documents here in the glass. This machine came from the city of Buffalo, New York, police sex crimes division. This machine has 249,000 copies on it, total copies. Prints has 42,000 prints on it. It's also used as a fax machine.
It took Junton about 30 minutes to pull the hard drives out of the copiers. Then, using a forensic software program available free on the internet, he ran a scan, downloading tens of thousands of documents in less than 12 hours. The results were stunning. From the sex crimes unit, detailed domestic violence complaints and a list of wanted sex offenders. On a second machine from the Buffalo PD narcotics unit, we found a list of targets in a major drug raid. The third machine from a New York construction company spit out design plans for a building near Ground Zero in Manhattan. 95 pages of pay stubs with names, addresses, and social security numbers, and $40,000 in copied checks. But it wasn't until we hit print on the fourth machine from a New York insurance company that we obtained the most disturbing documents. 300 pages of individual medical records, everything from drug prescriptions to blood test results to a cancer diagnosis, a potentially serious breach of federal privacy law.
You're talking about potentially ruining somebody's life where they could suffer serious social repercussions.
Ira Winkler is a former analyst for the National Security Agency and a leading expert on digital security.
You have to take some basic responsibility and know that these copiers are actually computers that need to be cleaned up.
The Buffalo PD and the New York Construction Company declined comment on our story. As for Affinity, they issued this statement that said in part, "We are taking the necessary steps to ensure that none of our customers' personal information remains on other previously leased copiers, and that no personal information will be released inadvertently in the future." Ed McLaughlin is president of Sharp Imaging, the digital copier company. Has the industry failed, in your mind, to inform the general public of the potential risks involved with a copier?
I think yes. In general, the industry has failed.
In 2008, Sharp commissioned a survey on copier security that found 60% of Americans don't know that copiers store images on a hard drive. Sharp tried to warn consumers about the threat, but
It's falling on deaf ears, or people don't feel it's that important, or we'll take care of it later.
all the major manufacturers told us they offer security or encryption packages on their products. McLaughlin showed us this one from Sharp that automatically erases an image from the hard drive.
How much does that component, that option, cost on a machine like this?
$500.
But evidence keeps piling up in warehouses that many businesses are unwilling to pay for such protection, and that the average American is completely unaware of the dangers posed by digital copiers. The day we visited that New Jersey warehouse, 2 shipping containers packed with used copiers were headed overseas, loaded with secrets, on their way to unknown buyers in Argentina and Singapore. Armin Katayan, CBS News, New York.
Has anyone seen that before? Yeah. You know, it's scary stuff. I mean, it's, you know, and that's the thing with a topic like this. You can, you know, talk about the duty of what professional conduct rules say and all of this sort of stuff. But that just blows it out of the water, because really, you know, there are so many things, and it's not just photocopiers. It's you know, your phones, any sort of electronic device. It's your IT security within your company. It's, you know, leaving a laptop or a USB stick at the airport. I think there was sort of someone in the government that got in trouble because of that. And the difficulty with being the LPLC and watching this sort of stuff, you know, you come away and you go, you have to be careful. You know, and it's, to a certain extent there is that message, but you've also then got to sort of take reasonable steps as well. You've got to be aware of this stuff and think about it and approach it from a pragmatic point of view. Along the same lines, something to be aware of is the Legal Services Board issued these legal outsourcing guidelines year before last, the end of the year. Some of you might have seen it, some of you might have missed it. Worth having a look through it. It's more, I think, in response to well, it's obviously in response to the large firms tying up relationships with the was it ILP, I think, over in India, sort of the big data centres over in India where they do all of the discovery work and for a fraction of the cost here. Obviously there are concerns with that, but I think it's equally important to read through it because it talks about outsourcing. Really, yes, you could be outsourcing to India, but you might also be outsourcing to the local photocopier company down the road, and really the guidelines apply equally to that. I read the guidelines and it occurred to me, gee, next time I have to photocopy documents and I'm outside an Officeworks, what do I do? Do I just go into Officeworks and photocopy the documents, or do I make inquiries about whether Officeworks photocopiers have a hard drive with images in them, and what do they do with those images, and what training do they give to staff about all of that, and so forth and so on. So, and I suppose when you think about that, and this is something that's not in the ethical rules, there's confidential information and there's really confidential information. The rules don't distinguish between that. Any information is confidential, but I think as a judgment call, we know when stuff's very sensitive and we need to take extra steps to protect that. That's pretty much it for my slides. I'm probably finishing earlier, which is probably good. You can get home, get to the office and do some work, or certainly happy to take questions or comments. If you wanted to do some more work, you can read through those guidelines, do a comparison of the rules, or ask yourself about policies. Are there any questions or comments? Pick up those ideas.
In the case you referred to earlier, which went to the High Court, was solicitor law to pay the cost of the results.
Yes.
So, do you believe the solicitors are law to pay the cost of a cause of action against the solicitors who negligently discovered the equivalence of it? In other words, what is the duty of care?
Opposed one solicitor to another.
Because the case from DPP and Kelly, the Court of Appeal,
and anyone hear this? I might sort of repeat it. There was a case of DPP and Kelly in
the High Court in London,
about
the question of the duty of a solicitor to an opposing solicitor, which is the centrepiece for this analysis, because we're talking about the duty owed by solicitors who need to discover the document.
Yes. Yeah. Well, that's an interesting point. I haven't read the case and I can't really comment, but yeah, there's a potential for duties to be owed between solicitors. Someone asked me in the break about sort of the GT and Mayor case and the cost consequences. Obviously, for the client, that was fairly disastrous. They lost their senior and junior counsel. They lost the case. I think they ordered to pay costs of that. It may well be that that client had a claim against the solicitors. But in between solicitors, that's probably pushing it a bit further. I mean, I think the response from the other solicitors would be, well, there's the inadvertent disclosure guidelines and you're under an obligation to follow those guidelines.
Yes, but the solicitors who made the inadvertent disclosure were negligent.
Oh, they were, but I suppose, well, in that case, I think the Hernan Street that went all the way to the High Court,
yes, that's what I'm talking about.
The solicitors who received the documents, presumably on instructions, made the strategic call to argue that privilege had been waived. They made that call and pursued that at first instance at the Court of Appeal and the High Court. So I don't think the duty would extend to cover that in certain other cases. Yeah.
Have you come across any cases where the lawyer or the barrister, cases where lawyer or barrister has sought a ruling from either the LIB or the Bar Ethics Committee and has been cleared or given the go-ahead to act or act in a particular way, and then has so acted and then has had some kind of case brought against him or her? Because I know that the Bar Ethics Committee says you can use this But obviously a court will come to its own conclusion, and as you say, everyone has differing minds about the correct ethical approach. But what weight do these rulings have?
Well, there's the one that springs to mind is, and I can talk about it because it's a published judgment, is the Goddard-Elliott case. Fritsch and Goddard-Elliott. It was a decision of Justice Bell in the Supreme Court, huge decision. The underlying proceedings, it was a claim by a client against his barrister and solicitors in a family law matter. He was under a lot of stress, not surprisingly, because he was in a family law settlement. On the day of the court, leading up to the court, I think the solicitor had concerns about the client's capacity to give instructions, and the barristers, in fact, even sought a ruling from the Ethics Committee about that, and were told no, that they couldn't cease to act. I think there was almost along those lines about whether they could cease to act or not. And that was referred to in the judgment, that the barristers got this ruling from the Ethics Committee, but the judge really sort of said, well, they asked the Ethics Committee the wrong question. So, I don't know if the judge put it that way, but I think that was kind of the underlying thing. Or they didn't disclose everything to the Ethics Committee that they could have disclosed. Actually, I think it was, and that it's coming back to me, I think it was settled with the barristers, but the client issued the solicitor, and the solicitor, it came out that there had been this Ethics Committee ruling, but it really wasn't quite on point, so it didn't really, and it's certainly not binding. It doesn't give it rise to an issue of estoppel or res judicata or anything like that. It's obviously something that, probably more importantly, that the barrister could rely upon, or solicitor could rely upon if there are any disciplinary proceedings. But even because that would be something that you'd be relying upon to say, look, I acted reasonably. Even then, it could be said that you've asked the wrong question, or you haven't disclosed anything to the ethics.
How do the overarching obligations affect any of it? So that you've got this duty now of disclosure under the Civil Procedure Act. How does that impact on
confidentiality?
Yeah.
Well, I suppose it's the duty. The overarching obligations are duties on parties and their practitioners, and the practitioners need to advise their parties of their duties under the overarching obligations and so forth. But at the end of the day, you need to get instructions, and I don't think you could simply go ahead and just, breach client confidentiality without instructions and then just sort of say it was part of my overarching obligations. I think you'd have to do a bit more than that. But certainly, yeah, there's an interplay between the two.
Please join me in thanking Richard for a very thorough